Let us begin the discussion of assignment 2 of patent law for engineers and scientists. Moving to the first question we have. The first question is an exhaustive list of invention that cannot be classified as invention is given in. So this is in section 3. Section 3 provides for an exhaustive list of items that cannot be classified as inventions. So it was the Patent Act of 1970. The first option is correct. Moving to the next question we have. Section 3 talks about the mere discovery of a scientific principle or the formulation of an abstract theory or discovery of any living things or non-living substance occurring in nature. So you can see it talks about the mere discovery of scientific principle of formulation and abstract theory or discovery of living things or non-living things occurring in nature. So this statement is correct. Talking about the second statement, section 3 we talks about an invention of primary or intended use of commercial exploitation of which could be contrary to public order or morality or which causes serious prejudice to human, animal or plant life or health to the environment. So you can see 3b talks about the invention on primary or intended use of commercial exploitation which could be contrary to public order or morality or which causes the serious prejudice to human life or plant life health to the environment. So this statement is also correct. So both the statements are correct. Moving to the next question, the person skilled in the art is defined in section 2. It is defined clearly. The person skilled in the art of in the means Patent Act section 2 is there. Moving to the next question. Yep. Chapter 6 of the Patents Act 1970 defines about the anticipation. So Chapter 6 of the Patent Law defines anticipation. So talking about the next statement, Section 28 of the Patent Act 1970 defines anticipation by previous publication. No, Section 28 of Patent does not define anticipation by previous publication. So moving to the next question we have. Mere arrangement or rearrangement or duplication of known devices, each functioning independently, is described in which section? So 3F state that mere arrangement or rearrangement or duplication of unknown devices, each functioning independently of one another way, cannot be invention. So this is in the 3F. Moving to the next one, invention that can be patented must be, it should be new product or process, it should be inventive step capable of industrial applications. So all of the above are correct. Moving to the next question, we have, according to the section 30 of invention claimed in a complete specification shall not be deemed to have an anticipated, which means shall not be considered as anticipation by reason only of communication of that invention to the government. So you can see here clearly an invention claimed in complete specification shall not be deemed to have been anticipated by reason only by the communication of the invention to the government or any other person authorized by the government to investigate. Okay, moving to the next question we have. Mosaicing is allowed for determining, it is allowed for determining the inventive step. You can see here mosaicing allowed for determining inventive step. Moving to the next question. Statutory exceptions for patent is provided in the section of the patent 1970. So you can see section 3rd and 4th provide for exceptions to the patent with the statutory exceptions. It is there. Moving to the next question and the final question we have, an invention can be said to be anticipated due to, an invention can be said to be anticipated due to the publication of the invention, public working of the invention, and public display of the invention. So all the options are correct. So ABC is correct. Thank you very much. Please like, share and subscribe.